This being the final week of June means that it is the final week of business for the Supreme Court. Now, there were 3 rulings handed down today, but really no decisions on the 2 biggies here, the remaining cases. One, on the constitutionality of political gerrymandering. That's when you draw district lines here for specific political advantage, in these cases for one party, obviously. And in the other, it's on whether the Commerce Department can add a citizenship question to next year's census. We have them every 10 years. Now let's take a look ahead to those cases, both of which we expect to get tomorrow. And for that, let's bring in Amy Howe. Amy is the founder of SCOTUS Blog, the go-to resource for in-depth reporting and analysis of the Supreme Court and its rulings. A huge day tomorrow, seismic as it relates with electoral consequences on a couple fronts. But before I go into the individual, both the census and the gerrymandering issues before the court, let's talk about both motive and timing. We have documented, and in some cases even overlapping principles that talked about the political motivations, both for the census question and certainly on how to gerrymander a political map. But when that information or that paper trail became apparent, how does that coincide with when the court both took the cases and both decided, in effect, where they were going on this, and how will that impact what happens tomorrow?
So that is kind of the $64,000 question in both cases, is whether or not any kind of partisan intent is going to play a factor in the court's decisions. In the census case, this has been something that the challengers have suspected all along, but it wasn't really a part of the Supreme Court case. However, in the past couple of weeks, the issue has sort of bubbled to the top again with new evidence that has come in from the files of a Republican redistricting strategist from North Carolina. And the challengers say that this evidence is relevant to the motives of the Secretary of Commerce, Wilbur Ross, because they say that it shows that this strategist may have influenced the decision to add the question about citizenship to the census. And there's been this back and forth, even in the last 24 hours at the Supreme Court, as challengers in this case and in the case in Maryland try to get the Supreme Court, in essence, to pay attention to this evidence. In the partisan gerrymandering cases, there's some evidence in North Carolina of certainly that the Republicans drew this congressional map to try to provide an advantage to Republicans at the expense of Democrats. And then in Maryland, it's not quite as obvious, but the challengers in the Maryland case say that this congressional district in Maryland, Maryland's 6th district, was drawn by Democratic election officials in Maryland, in essence, to punish Republicans living in that district for their support of Republican candidates.
Well, let's start actually with gerrymandering, because there was no attempt to obfuscate or disguise the motive. I mean, you had 2 Republican lawmakers, one a state senator, one a member of the House in North Carolina. And the money quote is, "I propose that we draw the maps to give partisan advantages to 10 Republicans and 3 Democrats, because I don't think it's possible to draw a map with 11 Republicans and 2 Democrats." And he said that in 2016. Now, to the point, they're making it clear what obviously goes on both sides in different political parties and different state houses, but the goal was to advantage one party to the utmost. My question is, let's say the court says, okay, you can't do this. Is there a remedy? Is there a way to who decides who redraws this, and where does states' rights starts? Who is it? The job of the feds? How do you find an impartial group to basically reconstruct the map of America?
And that's kind of plays into the difficulty that the justices have had. I mean, the first question that the justices have to decide in these partisan gerrymandering cases is whether or not partisan gerrymandering is what the legal term is justiciable, whether or not it's something that courts can get involved in reviewing or not, or whether or not it's something that should be left to to the political process. And if they do, then they have to lay out some kind of standard for what courts should do going forward when they're faced with these claims of partisan gerrymandering. And the fact that it's so difficult to figure out what a standard might be, I think, is playing into the concerns of some of the court's more conservative justices as they try to decide whether or not it's something that courts should do at all. So, how do you decide? I think everyone takes as a given that, of course, the legislature is going to consider partisanship to a certain extent, but how do you measure when that all of a sudden becomes too much? And I think there's a real concern, even if you can come up with such a standard among some of the justices, that courts are going to get, are going to become overwhelmed reviewing these different partisan gerrymandering claims. We have the census case reflects. We have a census every 10 years, and every time when you have a new census, states have to redraw their legislative maps, and so this is going to be this sort of constant flood of partisan gerrymandering cases.
And to add a little more color to a story you were talking about, the man's name is Tom Howe, who passed away. His daughter finds in the hard drives, and he was known as the Michelangelo of gerrymandering. What a title to have. But anyway, he wrote drafts that we know went to, as you said, Wilbur Ross. And in that, he said, you got to add a citizenship question to the census. It'll allow Republicans to draft even more extreme gerrymandering maps here to stop Democrats. So that was the motivation behind it. We then know Wilbur Ross gets it. My question is, if, as the Supreme Court has clearly said, the job basically of the census constitutionally is actual enumeration, which I believe, help me with my translation, is real counting of real people. If we know where the motivation came from for the question, and we also know, I think it's explicitly said, what the census is intended to do is to do an actual counting with real consequences for states if there's an undercount, then how can the court find that this is a legitimate question to have on the census? Where would the rationale be from both the precedent standpoint and also where we know that this is coming for pure political intent?
New evidence about Thomas Howe is not actually officially before the Supreme Court, because the Supreme Court took up the question of just simply whether or not Wilbur Ross, when he decided to add the citizenship question, acted in accordance with the federal laws that govern administrative agencies. The Federal District Court in New York, which is the decision that the Supreme Court is reviewing, didn't get to this question, actually ruled against the challengers on the question of discriminatory intent, and said, there's not any evidence about it.
So will Roberts have to kind of punt this? Is that the betting odds that tomorrow, the timing of this, there will be no Friday session, it'll be over tomorrow? I understand there's a conference even scheduled after the rulings are released. Is it, and I'm not gonna hold you to this, but is it an educated guess here that they're going to try and not rule on this thing one way or the other because of the political overtones?
The idea that they, on something this important, that they would say that the government, that they wouldn't rule on it, is kind of unimaginable to me, because the question is so important. But it's so messy that at this point there's very little in this case that would surprise me.
And just in terms of the new makeup of the court, I've seen 3 progressive justices all come out, and some more thinly veiled than others, saying the basic premise that we work off of established precedents and may not be something that in the very near future we'll recognize. When you heard Ginsburg and you heard Breyer and you heard Kagan say similar things along those lines, what was your takeaway from it?
So they're talking about the principle called stare decisis, which is the idea that courts will normally stick to their prior cases. They won't overrule their prior cases unless there's a good reason for doing it. And a couple of times this term, the Supreme Court has gone ahead and overruled its past cases, much to the consternation of some of the court's more liberal justices. And the more liberal justices are really kind of making a big stink when it happens, because they're thinking not just about these cases this term in which it's happening, but they're thinking about the long game and some of the other issues that are not currently before the court, but that could come before the court in the not too distant future.
Well, tomorrow's going to be fascinating, and it may lay the groundwork for some more really compelling sessions ahead as well. Amy, thank you so much. I really appreciate the time.
Thanks for inviting me.